Good afternoon, everybody. My name is Mark Gracie, and I'm going to be running the webinar today on the challenges for marketing managers from the General Data Protection Regulation, or GDPR, as it's most often known. Thank you for joining the presentation. I hope you can all hear me okay, and hopefully you can see the screen, which is a slide with a big blue box over a photograph with the title of the webinar on it. If you have any questions, in your control panel there should be a question section which you can put in your questions there, and hopefully towards the end there'll be 5–10 minutes for me to quickly pick out a few from that section and answer that. So as I'm going through, if anything comes to mind that you'd like clarifying, or you've got any questions on, then ping in a question there, and I'll try and pick it up later. So as I said, my name is Mark Gracie. I run a business called Flavorify Digital, which and I also set up the Digital Compliance Hub, which is an online platform, which I'll mention a bit more about later. My background is very much a technical one, and I spent since the mid-90s, in fact, working in the internet industry for a range of internet service providers and telcos, 15 years of which spent in a regulatory environment working with internal compliance and also influencing external stakeholders. So I'm very familiar with things like the Data Protection Act, and indeed was a data protection officer for a certain period of that time, around the time that the Data Protection Act became law in the UK back in the late 90s. So what we're going to talk about today is very much about GDPR compliance and the new rules that are coming in to replace the Data Protection Act in the UK. And hopefully from this webinar, if you're not already familiar with the GDPR, you'll get some insight into what that's all about, and hopefully it'll make you think about whether it's going to be something that you need to worry about within your business or within your role, and ideally hopefully give you some clues and pointers as to what to do about it if it does. This is very much a marketing related webinar, so this is the stuff I'm going to be talking about and covering is all about how the GDPR impacts on marketing, and there's some significant changes coming where that will be the case. Before we start though, let's just recap and refresh everybody's memory and minds about what Data Protection Act is, and specifically what is the data protection regime all about. Well, in essence, it's about personal data. If you collect data for the purposes of delivering a service or for marketing, if it's personal data, so it relates to a living individual as opposed to a corporate body, then it's covered by the Data Protection Act. And it's typically thought that that's only in a digital environment, so online databases, emails, email lists and that kind of thing, but actually if you order your data in a paper filing cabinet in a particular way that gives it some structure and control over the data in that filing cabinet, then that also is covered by the Data Protection Act. But in essence, it's about processing of personal data, and the Data Protection Act introduces a set of rules or principles, there's 8 of them, around what you can do with that data, that ranges from the fairness of the processing, the reason why you've got that data, keeping it up to date, how long you keep it for, the rights of the individuals whose data it is, i.e. the data subject, which covers things like data subject access requests, the ability for an individual to ask for copies of what they're doing or what you're doing with their data, and things like security and how data is transferred across international borders. In a business-to-business environment, in case any of you specifically aren't business to consumer, there is a bit of uncertainty. If you talk about personal data, therefore it's not business data, it doesn't really count, but in general that's the case, and there are some rules, particularly around privacy regulations and privacy electronic communication regulations, or PECA, which set out what you can do with regards to marketing to businesses. But it's worth bearing in mind, and this slide here is about just reminding everybody that actually there are some types of business data that is treated as personal data in view of the Data Protection Act, and will be continuing to be as part of the General Data Protection Regulation. Specifically sole trader. If you have data that relates to sole traders or partnerships, partners in a partnership, then that is in fact personal data in the eyes of the Data Protection Act, and will be also within the General Data Protection Regulation, and should be treated as personal data, which means you can't market it, use that data in a way to market in the same way as you would generic business data. And actually, even an individual's email address within their business, that too is personal data, but the privacy regulations allow you to use that data for marketing purposes, provided you provide an opt-out, and what you're marketing to that person is relevant for their role. So there are some nuances, and there's a lot of confusion. I've seen a lot of articles and stuff online talking about how the GDPR is going to change what B2B businesses are doing with their marketing and their data, when in fact actually there's very little that's changing. It's only if it's impacted by something like the fact that the data is relating to sole traders. And in fact, I've worked in businesses where there was no clear differentiation between the data as to whether it was an individual and therefore personal data, a sole trader, or a corporate or business data. So the decision was made across the business that we would treat all data as personal data, and it may be that that's something that you might want to consider as well in this journey. But in a general sense, data protection and the General Data Protection Regulation that's coming is all about personal data. So where are we right now? Well, as I said, we've got the Data Protection Act, came into force in 1998 on the back of a European directive, the Data Protection Directive. Because it was a directive, it was implemented in sorry, I was just slightly distracted by the fact I've got two T's in directive on that. Sorry about that. It was implemented in member states as a law. So that's why we have a Data Protection Act, and different European member states have different interpretations of the law as well. And so the European Union in 2012, well, actually prior to 2012, started looking at something as an alternative, and in 2012 published the first draft for the General Data Protection Regulation, which was eventually published last year, with a 2-year sort of cooling off period before it became law. So it's law right now, but it's not enforced until 25th of May 2018. And between now and 2018, we've got to think about what that might mean to all of our businesses and the data that we are processing. And there's expected guidance from the Information Commissioner's Office, that's the ICO, and the Article 29 Working Group, which is a group of all of the member state regulators. So the ICO is ours, for example. So over the next year, we can expect to see quite a lot of guidance and information about how certain aspects of the GDPR are to be interpreted. We've already got clarification on things like the Data Protection Officer role, and the Information Commissioner is consulted on its interpretation of consent, for example. So, and as it says there, 25th of May 2018 is when the GDPR comes into effect. It's a European-wide regulation, so it impacts the whole of Europe and will replace the Data Protection Act in the UK. And then, of course, one of the issues that I think the governments and the EU have struggled with is the fact that the UK is leaving Europe, but probably not until 2019. So there's a lot of people out there that think that we don't need to worry about this, but actually, if you do the maths, we've got at least a year of the GDPR before we leave Europe, and then what happens at the point of Brexit still needs to be determined. But the truth of the matter is it's unlikely that we won't have something very similar, if not exactly the same as the GDPR going forward post-Brexit. So before we get onto the sort of the nitty-gritty, as it were, about marketing and how that's going to be impacted by the General Data Protection Regulation, the two key areas where marketing is going to be impacted are highlighted there: children and consent, and I'll come on to those in a bit more detail in a minute. But this fan diagram represents essentially 10 of the main changes that you can expect to see with the GDPR. Very briefly, Scope is changing, which means that, as I mentioned, it's a European-wide regulation, so it covers the whole of Europe, and is also extraterritorial, which means that it applies to anybody processing data relating to European citizens, even if they're outside of Europe. So hence the reason I mentioned Brexit earlier, because outside of Europe we'll be processing European data, no doubt, or businesses will be. And also it extends the scope to include data processors in the regulation. So just from a definition point of view, you have a data subject, which is the data that of the person whose data it is. You have a data controller who's usually collected that data, and you have a data processor who may be the data controller, but is essentially the organization that is processing the data. So in a marketing scenario, you might, for example, collect as a data controller lots of information about your customers or potential customers, and you may pass that to a processor to do a marketing campaign. And those kind of things. Under the Data Protection Act, the processors have no legal obligations. It's all down to the data controller. Under the General Data Protection Regulation, processors are also as equally liable for all of the rules around data processing as the data controllers. Definition-wise, personal data is still defined as it is in the Data Protection Act. And with one exception, that it's now got an added definition around online identifiers. So if you collect data that relates to an online channel or maybe an IP address or something like that, and you can use that data to identify an individual, then that is now clearly, without any question of doubt, within scope relating to the General Data Protection Regulation. Children and consent I'll come back to. Individual rights, there's a number of rights within data protection right now. Data subject access is one I mentioned earlier. These are the rights that a data subject has to relating to how their data is processed, kept and stored and etc. The GDPR introduces two new rights. One is the right to have your data exported into a common format which can then be imported somewhere else. And also the right to be forgotten. So you can be asked to remove all data that's unnecessary for the purposes of delivering a service. Those are two new additional rights. And also for some businesses, particularly those who process a lot of data, they have a requirement under the GDPR to make sure that they are documenting their processes. So if asked, they can demonstrate how they process the data and in what way and through what systems. The by design element of this, the Data Protection Act doesn't talk about it, but there's best practice in terms of privacy impact assessments from the Information Commissioner, which is now encoded in the General Data Protection Regulation relating to data protection by design. So if you generate a new product or a service where there is going to be data collection, you need to have had a part of that sort of project development, so that's system or service development, come up with a clear plan of how you are going to deal with data protection. So data protection impact assessments, as they're called, or data protection by design, is a new thing encoded in law in terms of the GDPR. Data protection officers, you might have heard quite a lot about this. Certain types of businesses, particularly ones who process a lot of data on a regular basis, will have to have somebody official within their business who takes responsibility for data protection compliance. It doesn't need to be an employee necessarily, and doesn't need to be that's their full-time role, but it needs to be somebody who has that responsibility. And then the next couple, breaches and fines. Breaches, not too dissimilar from where we are in the UK right now. If you have a breach and data gets stolen, then there's a chance that you will need to report it to the Information Commissioner or the regulatory body, and you'll need to tell the subjects. It's slightly more stricter than we have right now, but is essentially an encoding of what we have in terms of best practice and interpretation of laws in the UK anyway. And of course the big highlight, the thing that always gets thrown about, is the fines. Maximum fine under Data Protection Act is $500,000. I think the largest they've ever, the Information Commission's ever fined is 400k to TalkTalk. Under the GDPR, there's a couple of tiers, but the maximum fine can be 4% of global turnover or 20 million euros, whichever is the largest. So quite a significant stick to beat any business about in terms of non-compliance, which is why lots of people are pushing that as the reason why you should be compliant. So let's move on to marketing related aspects of the GDPR. And I've broken it down into 4 main areas: consent, third-party data, what to do with legacy data, so that's data you already have, and ongoing management, which is something that should have been going on right now anyway under data protection rules, but maybe GDPR and its forthcoming implementation is possibly waking up a lot of people to the fact that they need to do a bit more than they've been doing in the past. So I'd say probably the most significant change that GDPR is implementing is the rules around consent and the consent for the processing of data. In a marketing environment, that has very clear ramifications with the way that you may be collecting your data and using it for the purposes of processing for marketing. So the GDPR says in one of its recitals that consent is defined as any freely given, specific, informed and unambiguous indication of a data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. Which is a complicated use of English to basically say you need to be very clear about what you're saying and doing with the data, and you need to get an affirmative or a very positive action for the person to sign up for the use of the data for that purpose. So in a marketing world, what this actually means is your messaging needs to be very clear that you're collecting the data for the purposes of marketing, and you need to have the ability for the subject to actually make a positive action to opt in. So there's no assumption of somebody thinking that it's okay to market to. You can't have pre-ticked boxes. In fact, they're even mentioned in the law as to something that's no longer allowed. So gone are the days of the untick this box if you don't want to be marketed to type clauses. And you can't use things like the fact that you said, would you like us to market to you? If we don't hear from you, then we won't be, we will assume that it's okay. So assumption is not something that you can use as an affirmative action that somebody wishes to be marketed to. So those are really 2 clear changes. They're not too far off where we are in the UK anyway, but actually they're much stricter in a general essence, particularly this thing about not pre-ticking boxes and having very clear messaging about what it is that you're going to have, what you're going to do with the data, and that is going to be used for marketing. And it needs to be, as I say, a positive opt-in, so somebody has to clearly take an action to say that they wish to be marketed to or have their data used for marketing. You also can't use consent without detriment to a service. So what that means is that you can't say that because you're using this service, you have no choice, we will market to you. That's not allowed. You need to be clear and upfront about who you're sharing that data with, or indeed you should be making statements about who you are and what you're going to do with the data, but also who you might be sharing that data with, which a lot of businesses tend to say they don't share data with anybody unless there's a lawful reason to do so. But if you've got a plan that you're going to use a third party to do some marketing for you, then you need to be clear that this data may be used for marketing using a third party and how that data will be managed. Not really a change, but consent withdrawal is something that individuals data subjects can request if they have the option to, and they need to have the option to withdraw consent, and you should be telling them how they can make that withdrawal at every opportunity. And if they make the decision to withdraw consent, then you need to take note of that and make sure that in your database you have the ability to flag people who have chosen not to receive further marketing. And then finally, you need to have some kind of record that is very clear that this is where you collected this data from and how consent was collected. So 6 very specific actions or controls around how consent works in a marketing environment, or indeed consent works generally with regards to the data you might be collecting. I think the big thing will be people will be needing to change the way that they are wording stuff, particularly on things like websites and forms that they use for the purposes of marketing, particularly in scenarios relating to email marketing and SMS marketing. There are other rules that impact telephone marketing and paper-based marketing, but nonetheless, in a consent scenario, it's clear messaging: who you are, what you're doing, why you want the data, how you're going to use it, and an affirmative action from the data subject that they wish to be marketed to. Now, there was one other area of consent which is changing, and this is a specific carve out in the rules relating to the consent from children. There are specific parts of the GDPR that talk about children's data, but basically, if you have a service that is aimed at children or is likely to be used by children, then there's a good chance that you will need to have some kind of age verification in place so that you can verify that they are indeed children. And if they are a child, you need to get guardian consent to use that data for the purposes of which you're asking the child for, and you need to explain things in a child-friendly way. So if you have privacy notices or the English you use at the point you collect the data and you're asking for consent needs to be child-friendly. Personally, I think having stuff written in English that can be understood by a child is probably good for most people, not just children, but there are specific parts of the GDPR that talk about making sure that you have child-friendly statements. And as I say, you need to then get guardian consent. So you'll need to think about how you're going to verify that somebody is a child or not, particularly if you have a service which may be used by children but isn't primarily aimed at children. So two clear areas of consent that are changing: the consent mechanism as a whole, and how that varies when it comes to children. But there's also some rules around third-party data that's also changing because of all the rules around consent and somebody having to make a positive action to consent for the purposes of marketing. Then if you're using third-party data, you need to carry out due diligence on the people who have collected that data and ensure that they are GDPR compliant, and that all of those things that I talked about with relating consent are indeed carried out. So you need to understand the provider or the source of the data and make sure that you can be sure that they have stuck to the principles of the GDPR, and in particular that they've got appropriate consent and they are able to prove that to you. And then you will need to keep a record to make sure that you can document how you come by this data and what you carried out from a due diligence point of view. And that last point isn't a bad thing to have in general anyway. If you are able to record and provide evidence and have policies and processes in place, that if you were ever investigated or had a query from the Information Commissioner or the regulator going forward, you would be able to have some documentary proof that say, well, actually, we got this data from this organisation and these are the steps that we carried out to make sure that they were GDPR compliant in the way that they collected the data. And if possible, if you're using a party to collect data on your behalf, make sure that they're making a statement around the fact that they are collecting the data on your behalf, and that's who they'll be sharing the data with. But marketing and things like email marketing and collecting data for the purposes of marketing isn't a new thing, which is why we've probably all got legacy data of one form or another, so data that you may already be using for marketing purposes. The Information Commissioner and indeed the GDPR recitals make reference to the fact that if you comply with the premises or the premise of GDPR, particularly around consent rules and the processing of the data and the purposes for collecting the data, then you don't have anything to worry. You don't need to re-audit your data and go back to everybody and re-seek consent. However, given that some of the new rules around consent are changing, if you have had pre-tick boxes and you may have collected data from third parties where you're not able to sort of verify the credibility of that data, then you need to think about what you can do from a legacy data point of view in terms of using that data going forward. And I'm sure you're all aware that actually, if we've all got massive databases of data, it's not a bad thing to actually clean your data on a regular basis anyway, and get a view as to people who are actually engaging with what you're sending them, rather than just having a massive database for the sake of having a database. So a GDPR audit around your legacy marketing data is probably a good thing for your business and your marketing activities anyway. But think about, how does that data, the way it was collected and then what you're doing with it, tie in with the new GDPR rules? Can you carry on using that data going forward under the GDPR? And then think about what you're going to do about it if you can't. I think in a general scenario, if you've got an email database which you regularly email and people have the option to opt out, and they continue to expect you to use their email for marketing purposes, so they're used to you email marketing them, then you can probably email them and ask them to re-verify the consent for going forward, and then obviously through what I was saying about the consent mechanism, make sure you record that. What you can't do is make a statement like, we'll assume that it's okay for us to carry on marketing to you unless we hear from you otherwise, because silence isn't considered something that is a positive consent to opt into anything. So you can do that, but you need to be careful if you've got data that isn't something you use regularly, or you're not so certain about, then just be careful. Honda got fined under the Data Protection Act a month or so ago because they collected a load of data from showrooms for a specific purpose, not for marketing purpose, and then they emailed them all and said, could we seek your consent? And somebody complained, and the ICO said, well, seeking consent is a form of marketing, and therefore if these people hadn't had their data collected with the purpose of it being used for marketing, which the showroom data hadn't been, then you're marketing unlawfully, and therefore you can't use email as a way to verify ongoing consent. In that scenario, you would need to consider looking at mail as a snail mail or paper-based marketing tools as a way to seek that consent. And I've certainly seen businesses who are sending out postcards to their contacts and just asking them to verify ongoing consent. Difficult to say what kind of return you get on that, and so it's worth just bearing those things in mind, that you just can't email people because you think that's the right step forward, unless you're absolutely certain that there's an expectation that you're marketing to the data that you've got. And as I said, that third box there, think about this as an opportunity to refresh your data as much as anything else, which isn't a bad thing in a marketing environment. But above all, make sure you record what it is that you've done and how you've gone about it, because if you've got records and you've got a policy or a process in place about how you've approached legacy data, then you've got some indication that you can throw at the Information Commissioner, should they start asking you questions, that you've actually taken some care and consideration in what you're doing, rather than just ignored the rules and hoped, sort of winged it and hoped that everything was going to be okay. And then finally, that sort of takes us on to what do we do with ongoing management? Well, this is something that most businesses should be doing anyway if they're processing data. If you've got data now, or you're planning on collecting data within the confines of what the GDPR says you can and can't do, you need to have a mechanism in place about the ongoing management, and that's about regularly checking. And I don't mean every week or necessarily every 6 months, maybe 6 months every year. Think about, is it worth a refresh of the data that you've got, and whether it's worth keeping all of those email addresses on your email list, for example. Make sure that you've still got mechanisms in place to enable the data subjects to withdraw their consent, and that you've recorded that so that there's no mistakes, that somebody's accidentally missed something and they're still getting marketed to, even though they've withdrawn that consent. Document your approach. As I say, policies and processes not only enable people to understand what their responsibilities are within the law and what you're aiming for as a business, but also helps you provide documentary evidence should you be investigated. And most importantly, make sure everybody in your team or even in your business fully understands what they should and shouldn't be doing under data protection. And because there's new rules coming, particularly around the consent mechanism, you should be looking at ensuring that your team, so if you're in a team of marketers, that all your people in the marketing team understand what's changing and how that might change their role and how these other things work around withdrawal of consent and so on. And also, hopefully, that may even be part of an ongoing process within your business to audit your business for GDPR compliance going forward, not just in the marketing team. And in fact, if anything you take away from this, so this is the bit where you perhaps think, well, actually there is something I need to do. What is it I should be looking at? Well, this slide here with the 5 columns, that's all about how do you prepare yourself, either as a business or even as a department, as a marketing team within the business, to ensure that you're meeting the compliance requirements that the GDPR will introduce next year. And I see it very much as a five-stage process, the last one being ongoing management, as I've just been talking about keeping yourself up to date and keeping everybody trained and making sure that all the processes and systems are in place, continue to work. But to get to ultimate GDPR compliance, you need to sort of start off at the basics. You understand what the GDPR means for your business, make sure your business has bought into the fact that you're going to need to do some work around this. And so, if you can get a senior buy-in, that might be a board level, and get the business to accept that they need to do something, even if it's just in the marketing team. But generally, kind of businesses that have marketing departments probably have other areas of their business that they need to consider data protection rules as well. HR, for example, and the way that sales and customer service people process and handle data for the purposes of sales and customer services is also another area that probably needs to think about what they're doing relating to GDPR. And you may be part of a working group yourself as a marketing person, as part of a wider company-wide GDPR audit compliance program, or you might want to set up your own little internal group within your marketing team to actually work out what it is that you need to do. And that takes you on to the next step, which is basically find the opportunity to work towards having a register of what data systems and policies you have in place relating to the processing of data for the purposes of marketing, or indeed any other aspect of your business, and then analyze it to see what actually this data needs to be cleansed, or certain actions need to be taken about it. Policies need updating. That can be policies, anything from your privacy notice on your website to your internal policy with regards to how you use marketing data. And you need to change your systems. And again, a system doesn't necessarily need to be your customer relationship management software or your Salesforce or anything like that. It could be, for some businesses, particularly small ones, could be just an Excel spreadsheet. It's still a system, and you need to make sure you have the means by which that system is compliant with the GDPR going forward. And then out of that, you should hopefully have an action plan which you can deliver across your business or across your team if you're specifically narrowing it down to marketing, to ensure that you meet the compliance by the 25th of May next year. And I can't stress enough that in training your employees as an ongoing management, or ongoing compliance management, or even as part of this program of preparing yourself for the GDPR, is an essential part. You need to make sure everybody is fully aware of what their responsibilities are under the law and what you can and can't do. And the last column is the manage one, which is what we've already spoken about. That's ongoing compliance, keep everything up to date. And also keep yourself up to date, because with new regulation comes the different interpretations of how that might work. So you need to keep an eye on what the Information Commissioner might be deciding, or indeed even a regulator in another European country might make a decision which impacts how the Information Commissioner decides to interpret elements of the GDPR. We've got Brexit. What might that bring, and so on. So there's probably a good 2 or 3 years worth of sort of uncertainty with regards to where things might go, and all we can work up with is what we're being told and what the GDPR says on paper. And also the other thing to look out for, of course, is ongoing guidance documents. I mentioned that the Information Commissioner has already consulted on consent. They're planning on publishing the outcome of that consultation in the summer, but it's difficult to know what that might look like and whether that's similar to the draft guidance that they've got right now. The fact that they're using that as an example of what you should and shouldn't be doing for consent may be suggesting that not much will change. But also other areas like the Article 29 Working Group, they're also looking at providing consent guidance. So where does that take you next? Well, you'll all have your own views on how that works. You obviously, how that works in businesses will vary from business to business, depending on the amount of data you might be processing, the type of data, what kind of marketing you do, what size your business is, and so on. But these are just some of the things that you might want to consider. As I said, I've mentioned training. You might want to run some internal workshops. You most definitely will need to carry out some kind of audit, even if it doesn't follow that 5-step process that was on the previous slide. But you need to manage your compliance and you need to take action. Now, one of the things where I can help is I have this tool called the Digital Compliance Hub, which provides a number of elements that can help your business get to grips with GDPR compliance. It's not just about data protection. I also help. It's also to help businesses with their privacy and marketing rules, web and data security, and I provide training and workshops as well. And it's a kind of a hybrid system. It's an online system. It's subscription based. It gives you advice and guidance, but you also can have support when you need it. And there's other opportunities to, for example, get discounted access to training and workshops, and access to one-to-one consultancy and things like that. At the moment, I only launched it last week, and for June, I've got a launch discount of 40% off per month. It's £125 a month normally, but you can get it with 40% off if you join up in June. And for being on this webinar, I can also offer you a free month trial, so you can have a look and have a look around it. And if you just use the code hub-free-month at the checkout, then you'll get the first month free. If you want to have a personal demonstration and be shown around it, then email me on demo@digitalcompliancehub.co.uk, or just have a look around and see what's there. In fact, what I'll do very quickly is, if this works, we'll switch over to just showing you very quickly the hub, and certainly some of the stuff that I've got in there that relates to marketing. So there's a marketing consent section, for example, which provides a range of things, including a sort of an overview, very similar to what we've just covered, the law in a bit more detail, but they're also some of the tools. So there's so I've got some walkthroughs that ask very simple questions, and along the way sort of explain why I'm asking that question, which will give you some input into what you might want to think about, and whether you need to make some changes. There's also a link there for training. I'm running some workshops specifically aimed at GDPR and data protection training for marketing teams, and you can get a discount as a subscriber for that. And then the other thing is, if you're looking at what your business might do regards to an audit, I have that audit plan, so that five-stage process all set out in here, and there's little snippets of things that you can take away. So there's a sort of a template for an Excel spreadsheet on how you might use that as for a data register and a system register, etc. So there's a whole host of information there that can help, and as I say, help and support is a key part of that. So if you need some stuff verified or checked, then I can help you with that. Okay, if you just bear me a second. Bye. Try and get back to my presentation. So that's the Digital Compliance Hub. As I say, please try it out. If you've got any questions, then drop me a line. So that's what I wanted to go through. Just checking the time. We got about 10 minutes, so I can see if there's any questions and pick up on any of those. I've got 4 questions at the moment. If you've got anything you can think of in the meantime. What I'll do is I will just quickly look through what I've got on here. So I've got a question: if a company has a marketing list where it's not sure what level of consent was given by individual customers and wants to use those records after GDPR is enforceable, how should the company proceed? Can it re-permission the entire list, or will it fall foul of current data protection? So that may have already been answered. I'm not quite sure when that was posted, but that's my point about legacy data. If you've got data at the moment and you're not sure whether it's compliant or not, you need to think about whether that data does match the rules for GDPR. And if it's not, you need to then look at how you can repurpose that for ongoing marketing. The only marketing, you can't use digital-based marketing, so email and text-based marketing, to seek ongoing consent. You'll need to look at alternative methods, so clean it against TPS and do telephone marketing, or look at sending a postcard or a letter seeking ongoing consent. The important thing is to remember that if you don't get that consent back, and make sure that your consent request is very clearly worded and it's a positive opt-in. If you don't get anything coming back, then you're going to have to take them off your database before you can use them. And another question, a very good one. How does this impact on e-commerce, particularly things like abandoned cart email marketing? That's a very good question. I mean, there's a whole host of online service scenarios where you might have data and how that data is processed for the purposes of marketing. Inbound marketing is a good example of how or automated inbound marketing is a good example of how you might be looking at collecting certain bits of data and how you do that. If somebody has abandoned a cart but has given you enough information, I'm just thinking on my feet with this one. I would say that the real test with any processing of personal data is if the data subject has a reasonable expectation that you're going to use that data for a particular purpose, then you're going to be safe. So if somebody has abandoned a cart and maybe at that point you've already asked them the question about confirming marketing, then I'd say you're clear to contact them. If you're contacting them simply to say, we noticed that you didn't finish your transaction, if there's anything we can help you with, then I think you'll be okay on the basis that you could say that there is a legitimate interest in making sure that is some way of processing it. But if you want to, Amin, I hope you can hear me. As that was your question, if you want to ping me an email and we can have a bit more of a discussion about that, and feel free to do so. I think that's something that is probably safe to do, but we just need to consider the means by which it is done. And there are things like legitimate interest which exist under Data Protection Act, which is, you could argue that you have a legitimate interest without harming the data subject's right in just checking that everything went okay, and therefore I think you would find that you'd be okay. Okay, so a couple of the other questions weren't questions; they were statements. So thank you for those. And if anybody else has got any more questions, now's the time to type them in the questions section of your control panel. Otherwise, we'll leave it at that, and thank you very much for joining.